Welcome to BoRAKyat TV. Assalamualaikum, salam sejahtera. My name is Firdaus Husni from the Malaysian Centre for Constitutionalism and Human Rights, MCCHR. So just a little bit about BoRAKyat TV and why we call it BoRAKyat. The reason why we are coming up with this initiative, and this is the very first episode, so I want to take my time to explain, is because we want to have a space, we want to create a space in which, in that space, we can have a conversation and share knowledge about the law, about human rights, the federal constitution, the highest law in our country, and essentially issues under the big umbrella of democracy. So that's why we call it BoRAKyat or BoRAKyat.
So basically the idea is to sort of very casually discuss these complex topics, to sort of assist in public understanding of these various issues. Now, today we have with us a very important guest, our special guest, Nizam Bashir. All right. Hi, Nizam.
Hi.
How are you?
Good.
All right. So today we would like to actually discuss about this particular topic called judicial review. So, perhaps before we go into the nitty-gritty of what is judicial review, etc., maybe you can share a little bit about your background or experience concerning the topic.
Well, I've been involved in judicial review cases, I think maybe since 2006. And I think I became involved in it in the quintessential way that public law lawyers become involved in judicial review cases. We are accidental public law lawyers. We take an interest in one area of the law, and all of a sudden we are doing cases about it. And that's a summary of how I came into doing public law cases. If you talk about the type of cases I've been involved in, invariably it's always been something, I think, with a religious component, either speaking on behalf of the religious authorities or speaking against religious authorities. So I'm essentially, the guy with two sides or two faces on the coin. Yeah. So I suppose if the issue is, to my mind, I suppose contrary to public law, then I will speak up, either against it or in favor of it if it's pursuant to the rule of law as well. Yeah. So.
All right. Okay. So let's say, people out there hearing the word judicial review, semakan kehakiman, for the first time, they'll be like, what is that? Apa tu? So how would you explain that?
Well, when you talk about judicial review or semakan kehakiman, basically it's in a way a call to arms, for the courts to look at a decision and see that it's consistent with the rule of law. Okay? So the courts, of course, when they are carrying out that process of, reviewing the decisions in question, they don't reconsider the conclusion as such. It's more about looking at the processes and seeing whether the processes have been compliant in the various grounds where judicial review is concerned. And so long as it complies with that process, by and large, the court won't substitute its view as to whether the conclusion arrived at by the decision maker was correct or otherwise. That's the gist of it, lah. So it's just making sure that things follow the law. Yeah.
All right. So perhaps to help understand the process, essentially, right? Just trying to understand, is there a specific class of people who can file for judicial review, or is it something which is can be filed by anybody and anyone?
Yeah. In the bad old days, it used to be a bit more conservative. So standing was a big issue. But fortunately, the rules regarding standing has been relaxed a bit. Now all that matters is you are adversely affected by the decision. The phrase adversely affected, it can be a little bit vague, I suppose, when you're first reading it. But it simply means that although you don't have to have your private rights affected, by the same token, if it's like a spectrum of facts that can be in play. Yeah. But at the same time, if you're a mere busybody, you simply take an interest in the matter. The courts in Malaysia have not accorded that person the ability to file a judicial review cases. But if you can show in some way that your rights are affected, it doesn't have to be a private right. You can have the right to be heard. You can mount a judicial review case in courts.
All right. So let's give it a scenario.
Yeah.
So let's say I am a Selangorian, and then I'm driving past, say, Pahang, right? And then I see pollution. And it's something that I feel affected. I don't feel that I can truly enjoy nature. And I found that, there's something wrong. Why is this even allowed? Can I take an action? Can I file a judicial review?
Well, it's not purely a hypothetical scenario in the sense that there were these two ladies who were residing arguably in KL. They filed a case impugning the Kelantan Sharia legislation. And, some people are saying, hang on, you're just there like maybe on the weekends back in the hometown. But despite the fact the case made it all the way to the federal court and they were granted the right to be heard. So, I think as long as you can show some sort of connection, merely because you are a transient person doesn't mean that you're prevented from having your case being heard. I don't think the case is that strict, or the standing requirements are that strict. As long as you can show, because the problem is, for example, in Sharia matters, it can be a little bit more sensitive in the sense that arguably the person who's passing through is subject to the Sharia laws of that state. Yeah, so I think the considerations can be a bit different.
I mean, following up from that question, are there any circumstances where challenging, or rather filing a judicial review is justifiable or permissible? So what are the requirements that are needed to file a judicial review?
Well, I think as long as you can show that the typical grounds for judicial review is engaged, okay, and the typical grounds would be you can show that the decision was tainted by illegality in some way, tainted by irrationality in some way. There's non-compliance with the procedural framework, let's say in the Act. As long as you can show that any of those grounds are engaged, you would be justified in terms of taking the matter to court and asking the courts for leave to review the decision in question. Yeah, so it's pretty broad. There are a huge sort of principles to be met that you can show. As long as you meet those principles, by all means file it. I think I suppose when the question is phrased as whether it's justifiable or otherwise, it's a very Asian thing to some extent, going against the government. You shouldn't do that.
Yeah.
We're all well brought up, etc. Don't speak against our elders and all that. But ultimately, there are some things, unfortunately, you are entitled to differ in terms of how people are looking at things. Decision makers in question, in particular, yeah. So, and when you talk about illegality, when someone is not following the law, what the law requires, yeah, certainly you're entitled to bring the matter to court. And I think you shouldn't be too afraid about that.
I do think in a way it's good that judicial review is deliberated through broad principles, rather than very narrow and specific consideration. And taking on from that, I want to zoom in the discussions within the context of human rights. And so 2 questions. First would be, how do you think judicial review helps in the larger conversation of the promotion of human rights? And following up from there, I'm also asking, as MCCHR is part of a larger civil society in Malaysia, can NGO like MCCHR file a judicial review? Not for the fact that it affects us, but because of the fact that what we do at MCCHR is to promote and protect human rights. So what do you think?
Let me not answer the second question
Come on.
so explicitly. But I would say this: we have got a few cases filed by the Bar Council. They have filed, I think, a judicial review against a decision affecting maybe some cases involving pardons, involving maybe non-prosecution, etc. Yeah. And I think, the connection that those bodies have with these issues, rule of law, etc., is not too tenuous, in my view. Yeah. I think you talk about the Bar Council, for example, they've been involved in issues involving rule of law for, more than 50 years, isn't it? Yeah. So to say that a body like that would have no standing, I think is a little bit strange. It would be a little bit surprising. MCCHR, I wouldn't say they have not been involved in, asking the community to be concerned and cognizant of matters involving public law, but maybe they need a little bit more time.
All right.
Right. So coming back to the topic of human rights. So how do you see judicial review in the context of human rights? How useful of a tool is it in preserving and protecting human rights?
So that was actually the first question that Firdaus asked, which I didn't quite answer. So I was hoping I was going to be able to avoid answering that. But since you caught on to that tactic, whenever you do judicial review cases, it's of course not just confined to public law grounds per se. I would say a distinct independent ground is also, human rights, and even various matters in terms of construction of the federal constitution, etc., which you can arguably also say is also connected to illegality, because that's the parent legislation, so to speak. Yeah. So if you talk about human rights, that's the entire part 2 of the federal constitution. And if you look at Article 4 of the federal constitution, any law that's passed after Merdeka Day that is not consistent with the federal constitution is void to the extent of that inconsistency. So certainly part 2, since it's part of the federal constitution, if anything is inconsistent with part 2, that is contrary to Article 4, and the law in question would certainly fall away, would certainly be declared as void. So any judicial review cases that raises matters of involving human rights certainly, would be promoting human rights, because you are having that dialogue about what is the content of that human rights vis-a-vis whichever article, whether it's Article 10, 8, 5, yeah. And you've had a number of judicial review cases where those matters were considered. You look at Judicial, for example. Those were, was a case where transgendered individuals were detained, and in the course of that detention, they were beaten up. Yeah. And the court looked at the content of Article 5, Article 7, Article 8, and considered whether or not those articles were breached by the decisions or the actions of the relevant officers. And not just Judicial. You've got a whole slew of other cases where all these matters, there's that dialogue happening between what exactly is the human rights component in the decisions that were impugned, and whether those human rights were breached by actions of the relevant officers. Yeah, lots of cases.
Okay, so you mentioned illegality being the ground for judicial review, right?
Yeah.
So other than illegality, so what if in a situation where the restriction is permitted, right? But it doesn't feel right. An example would be if we were talking about MCO, right? During the pandemic, and the federal constitution allows our freedom of movement to be restricted where there is public health issues, right? I think, we all can agree that. But let's say pandemic has ended, but the government still decided to maintain the MCO. Would illegality be the ground here because public health is allowed?
Yeah, well, there are, broadly, I would say there are 3 grounds
Okay.
for judicial review. There's illegality, there's irrationality, and of course, procedural impropriety. So, of course, whenever a law is being passed, there is some basis, some premise as to why the law is being introduced. In the context or in the scenario that you have posed, I suppose it would be irrational to say that those restrictions should still be in play when the facts relating to that is no longer there.
Okay.
Of course, we have, I think, some nostalgia where that is concerned. For 50 years, we had an emergency in Malaysia,
Yes.
So, but I think it's easier perhaps for those sort of decisions or legislation or policies to be tested because I think we are a bit more familiar with principles involving judicial review these days. I think you talk about the 50s, late 50s, early 60s. Even conversations about the Constitution, it was like reading a slightly different book, So it's good now that it's good that now I think when we're looking at cases coming these days, when you're talking about constitutional rights, etc., it's a bit easier. Judges are maybe a little bit more open, looking at whether it's a question of Article 10, issues of speech and expression. They're a bit more open to those conversations these days, as maybe in the 60s or 50s. Yeah, and that's understandable because we were young as a nation, and I think we were trying to find our feet. So it was very paternalistic in some ways. Let's protect the state, let the state grow. But I think now maybe that check and balance is in play, and judges, and I think we are a bit more prepared to impose some restraints. And I think we partly also because the landscape has changed these days with the internet. Yeah, people are a bit more exposed to things, controversial ideas, etc. And I think it's a good thing.
Okay. Earlier you mentioned I think there were three items which come under or which would justify judicial review. So I believe it was illegality, irrationality, and procedural impropriety.
Yeah.
So now, of course, when we talk about illegality and procedural impropriety, there's of course a clear comparison or clear standard which you can contrast with, where it's either against the law or procedures were not complied with. But I'd like to zoom in on irrationality because I think that one seems a little bit unclear. So, would you perhaps share what irrationality entails? What is it? How do we define it? How do we make sense of it?
If for example a particular decision is made on irrational grounds, let's say we come back to the example that Firdaus was giving just now. There was a policy in place imposing certain restrictions in terms of movement at a point in time when there were health concerns, health issues, and certainly at that point in time, it was rational for them to introduce that particular policy. Facts change. Those concerns no longer apply. And if those concerns no longer apply, is it rational for that policy to be implemented? The answer to that is certainly no. So that is where it's a question, I suppose, of there being a factual premise, but which no longer subsists, but you're still applying the policy in question. Similarly, if let's say there is a wrong appreciation of the facts, meaning to say they thought that facts exist. In actual truth, that facts do not exist. Can you still apply the policy? The answer to that is no. Yeah. So there's actually some nuances to that as well. I suppose what I would suggest is see a good lawyer.
But what does that entail and what do you need to do exactly? Because sometimes, right, the fact that you have to go find a lawyer and then they'll tell you what to do, that in itself can be quite daunting because they still don't know what to expect. So,
yeah, I always tell my clients, start from the beginning in the sense that start from a very simple sort of platform whenever you're looking at any decision. Does it sound fair? Adil tak adil? Okay. Kalau misalnya kata tak adil, you don't have to jump through hoops and all that. Anyone looks at it, something is wrong there.
Yeah.
Okay? So, of course, as lawyers, we are very fond of, breaking things down and it becomes like a very complex process. But ultimately, some matters just sells itself. I'll give you a very good example. Some years back, I think it was about 2 years back, we did a matter whereby the relevant authorities revoked the halal certification of our clients. And they revoked the halal certification on the basis that they found porcine DNA. DNA babi, at the premises.
All right.
But they came to that conclusion without visiting the premises of my clients.
Oh.
They made that conclusion only on the basis that the supplier had that issue at his premises.
Oh.
And because of that, you take supply from him, So therefore, we are also revoking yours. So, of course, they took the gentler approach. They went, the beradab, very traditional way, and basically said, tak apa, we satu and all that. But despite that, they didn't even reconsider that decision. So, ultimately, we took them to court, and it became so apparent to the judge who was listening to the matter that there was something wrong with what happened. We didn't even have to submit. We just sat down and he was submitting for us. And ultimately we got the order that we wanted.
Oh, I see.
It became a consent order, mind you, at leave stage.
On what basis was it? This is a judicial review case,
Judicial
yeah?
review
And
case,
on
yes.
what basis is that? Procedural priority?
Well, many grounds, including even illegality, because there were some
Okay, I
things they
see.
didn't comply with, as well as PI, in the sense that there were steps they were supposed to take in a relevant manual, including coming and taking samples. Samples also, there's a process for it. They didn't follow it.
Oh, I see.
Yeah. So the point I'm making is sometimes things can become so apparent in terms of whether it's right or wrong. You don't even have to go and see a lawyer and you will know that something is wrong. So in those kind of instances, for example, some of the Orang Asli cases that happened some time back, Sagong Tasi and all that, you had, essentially lawyers acting pro bono for that community and making sure that they got what was due to them in law. Yeah. So lawyers do good things.
So not all lawyers are doomed to hell, right? So let's just say perhaps we can I suppose this is something that my question is more posed for the young lawyers out there who want to get into public law and want to perhaps help people on a pro bono basis in judicial review, for example. So what would you advise them, or what are the life lessons that you have learned that you would like to impart on them?
Well, generally, when I suppose, trying to learn a new area of the law, because you may have either theoretical knowledge, or you don't have any knowledge at all. Yeah. So the first step always is be prepared to carry bags. Okay. Be friends with senior lawyers. Don't be shy. Buy coffee for them by all means. Over the years, if I were to look back, one of the best lessons a senior lawyer imparted to me was this, being encouraging and, making sure that I wasn't shy of being friends with seniors, and because he encouraged that indirectly by way of, organizing lunches very frequently between him and some of his other lawyer friends, that became a way for me to learn exactly how to practice law. So coming back to your question about judicial review, to me, young lawyers should do that. You have a lot of senior lawyers, unfortunately, sometimes being short of time. You can actually ask, whether you can assist in whichever public interest matters that they are doing. And in that way, you learn, I suppose, the tools of the trade, how they approach a particular subject or area of the law, the procedures involved in judicial review cases. And once you are armed with that knowledge, then of course you can start doing cases on your own. But at the same time, because you already have that sort of relationship with the senior lawyer, he's also able to sort of give you that pointers whenever you're stuck with whatever issues. Yeah. So life lessons wise, be friends with senior lawyers. Don't be shy. We all start somewhere, and there's nothing to be ashamed about that. Einstein wasn't Einstein overnight. The greatest surgeon in the world didn't become the greatest surgeon in the world. He started by doing all the small things. You'll get somewhere. Start with the small things, I suppose.
So in a sense, it comes back down to beradab lah.
Adab is good lah, but sometimes kena kurang beradab also. When the law is unjust, don't be too beradab.
All right. Okay. So, back then, when I was still a practicing lawyer, I remember someone asked me this question because this was in relation to the fact that I was very much involved in bar council activities, talking about constitutionalism and human rights issues. And this person asked me, and I know it was a well-meaning question, tak takut ke? And you mentioned earlier that some of the cases that you do under judicial review is where you speak against the religious authority or you speak on behalf of the religious authority. So I'm going to throw that same questions to you.
Well, there's a verse in the Quran. I mean, if you talk about where do you find courage, and it can be whichever book.
Yeah.
There's a beautiful quote by Dean Koontz on doing good and being kind, and how it will sort of ripple throughout time, and that small act becomes a selfless act of courage down the road. But coming back to that Quranic verse, if you see even essentially your parents doing wrong, you have to be bold enough to say that, look, that's not right, that's not the way to do things. But of course, there may be this, coming back to this question of adab, there may be ways of doing it. But when you're talking about the state, at the end of the day, look, we vote our lawmakers in, yeah, and we expect them to play according to certain rules, yeah. And the rules is there in terms of the federal constitution. The powers are all distributed according to the various levels of lawmakers that we have, whether federal or state. And I don't think you're doing a wrong thing by saying follow the law. This is like a football match, man.
Yeah.
If you see Man City playing against Man U and the referee is not being neutral, I mean, you get upset. So it's the same thing where law is concerned, or where even decisions are concerned. If it's biased, if it's not consistent with law, that's not the way to do things.
All right. So perhaps coming back to, I think you earlier gave some examples of previous judicial review cases that you've done, or you've heard about, or you've read about. So which case in particular perhaps do you find most interesting? And what were the considerations in that particular case?
Well, I think, I mean, if I were to speak personally about what the answer should be to that question, I suppose, cases that you have taken on, we as an individual have taken on, generally those cases are most interesting because you would have slept, eaten, showered with it for like 2-3 years, and you would have turned it over in every way possible, trying to find a solution essentially for the client. And sometimes you agonize about things, and as I mentioned earlier, the cases that come my way generally has got a religious component to it. So you agonize about being to some extent faithful to your articles of faith, I suppose. But at the same time, you're trying to ensure you balance that with how this person is dealing with whatever decisions the authorities have made, and how it impacts on their lives. One of the cases that I did some years ago was one involving a child out of wedlock, and what the naming laws were, which affected him. And the father, of course, wanted to pass his name to the child, so the child wanted to be, well, not the child, maybe the father acting in the, as a guardian of the child, wanted to ensure that the child has his name, been whatever the father's name was, yeah. But you see, and I had many parents calling me, on the phone, and just crying on the phone because they all accept, look, what they did was wrong, but why punish their child? And it was one of those matters where, I mean, you agonize quite a bit about it. Yeah, you want to do something that is, of course, right according to the dictates of your faith, but at the same time, you look at how it impacts on the life of that particular individual. Yeah. So those kind of cases, I suppose, and I'm sure it's the same if you ask other practitioners, what are the most interesting cases that they have done? It would be generally things that they sort of have argued along the way, because they probably have seen various facets, not just what is argued in court. Because you see things, I suppose, at a more personal level when you are spending time with that person, etc. Even when you're talking, I mean, that Juzaili case I was talking about earlier, Juzaili actually was a sequel. The first case actually happened in Malacca, which I argued. And you have to generally spend a bit of time with the individuals affected by the actions of the authorities, because you see how it impacts upon them. And, there's a lot of things that they will convey to you, which sometimes don't make it on paper, because some are emotional arguments. They're not legal arguments. And even in Juzaili's case, which I think was a more extreme version of what the community, the transgender community, have got to face. Meaning to say, I mean, whatever your issues may be in terms of the attire they wear, that's no excuse, no reason to beat them up. Yeah. So just because you may have the law on your side, it doesn't mean you can break the law by beating that person up, by preventing, for example, in some other cases, the right to counsel, which is what happened in Kasim Ahmad's case. Yeah. So sometimes I think the authorities tend to forget that. In that zest to apply the law, they sometimes unfortunately don't comply with the law. And I suppose when you're doing this sort of cases regularly, these are things you begin to see at a more micro level, I suppose. And sometimes you get a little bit enthusiastic also in trying to make sure that the law is adhered to by, I mean, whether it's authorities, whether it's the security guard at some corner somewhere. But sometimes it's also important to be a bit forgiving in some instances. Follow the law, but sometimes, otherwise you'd be like Moses and the baby, you split the child in two.
Yeah.
So it's only the mother that will say, don't do that. Yeah. So I suppose over the years, the one wisdom I suppose I've gained, 90% of the time, if you want to ask for a figure, follow the law, but 10%, be a bit more kind.
All right, so I want to wrap up these conversations,
Yes.
and I would say, personally, one main takeaway that I can take from our discussion is that when we see injustice, when we see human rights violation, the fact that it was done by the administration of the day does not mean we should accept it as it is. Does not mean, oh, that's how things are. The government, they know best. Because if that's the case, then the concept of judicial review wouldn't even be there in the first place. And it is through this judicial review process that injustice can be rectified, and human rights violation can be looked at, and in a way strengthen even more our human rights protection in the country. So I think that's what we have today. Thank you, Nizam.
Thank you for having me.
And this recording, we are doing it at our resource center at MCCHR, as you can see here. The collection that we have, and so I do want to spend a bit of time before we end it by talking about one of the books that we have in the collection. And this book is called Breaking the Silence, Voices of Moderation, Islam in a Constitutional Democracy. And I thought it's a fitting choice since we did touch a bit about religious authorities and even in some of the example of cases that you mentioned. And we notice here that you were the first contributor, the first article contributor here was Nizam Bashir. So you want to talk a bit about this book and the article that you contributed?
Well, since you were very kind in terms of giving me that space,
of course,
just to remind everyone, Cik Firdaus Husni also has an article here. But what I think I wrote in this particular book essentially was tracing the history of Islamic law in Malaysia.
Oh, okay.
And of course, I also touched on Sheikh Omar, Sheikh Aso, and whether some of the conclusions in that case was necessarily correct. But I think the ending to the article I thought was quite interesting. One of the things that I was talking about was that we should get the balance right, even in our, I suppose, desire to ensure that Islamic law manifests itself within the nation. But I think there's a beautiful counterpoint to that desire, in the sense that you've got Part 2 of the Federal Constitution, there's human rights there. So it tempers, I think, the idea that there's only one version to what is right, to what is true. And I think we must accommodate something that's more diverse and more forgiving, more, I suppose, a more concrete human experience of how Islam is realized in someone's life.
I see.
Yeah. I don't know whether that's there in the article. It's probably not there. But
Well, people have to read it to see for themselves.
yes, yes.
All right.
But the sentence that I wanted to quote was this. Because I asked a key question in the entire article: is it possible to submit to God while promoting human liberty? And if you can answer that question and strike that balance between the despotic experience of theocracy and the godless experience of secularism, Malaysia will prove to be a model state. So
Nice.
yeah.
Thank you. All right. Okay, so I think that's it for today. Again, I want to thank Nizam. And I also do want to share that this is only the first episode. So please do follow us, MCCHR, on our website. We are also on Spotify. And if you want to know what's the next topic of conversation, do watch out on our, all of our spaces on social media, and give us a follow, like, and then let's continue the conversation online as well. Now again, my name is Firdaus Husni.
Azad Akbar. And thank you. Like, follow, and subscribe us.
To be a land that's peaceful and strong, which fights right against wrong, and all of its people